All right, I want to welcome everyone to Legal Issues Facing Small Business Owners. We have SCORE Boston's own David Berman. He's got a lot of information to share with you today, but as we get started, I want to make sure, if you're not familiar with SCORE, that you know all of the things that we offer. Our biggest goal is to share information with small business community, and we do that in several different ways through our website, score.org. Lots of information there as in the form of videos, articles, templates you can download, lots of wonderful bits there. So I strongly encourage you to take a look at that. The other way is through our workshops and our webinars. We do have both in person and online in this fall. So watch for our newsletter, social media posts, and you can also find a listing on the website as well. The other way we provide information is through our mentoring, and it's probably the most important thing that we do. And our mentors are volunteers. So the mentoring is free and it is confidential. And our mentors have a variety of skill sets and experiences to share with the small business community. We're working with those that are trying to decide if small business is right for them, those that are in that planning phase, and those that are in business, perhaps they're growing or getting ready to exit their business. So we work from beginning to end, and definitely you don't need to already have a plan in place. You don't already have to have an LLC in place. In fact, we prefer you come to us from the start so that we can make sure that you're on the right track to being successful. A beginning session, they want to know about you. They want to know about your goals and your challenges, and they're going to work with you to come up with a plan to meet those goals and overcome those challenges. And it's not uncommon for mentors to invite other mentors in as your needs change and grow. And it's a wonderful experience, I think, for clients. And they say that, you know, after working with a mentor, that you have more chance of success with your business. So if you are interested in a mentor, it's a very easy process. Probably the easiest way is to go to the score.org website, and there's a blue box that you can put in your zip code, and that'll match you to the chapter that is nearest you. There's a form that'll pop up that'll ask you a little bit of information. There's a free form section if you just could tell briefly what your business is or what it will be and what is your immediate need. We can match a mentor to get things going. So today we do expect a good group with us today. So if you can put questions into Q&A, we will get those answered as is appropriate. We are recording, and this recording will be posted to the score.org/Boston website. On the blue bar under the local workshops pull down is previously recorded webinar. It usually takes 24 to 48 hours for it to post there. We don't generally share the slides with this presentation, as most of the information is going to be given to you verbally. So the recording will be an asset to you when you're ready to review any of that information. So I'm going to go ahead and let David get started. It's all yours, David.
Well, thank you. Thank you. I'm going to just share my screen for a second so I can sort of put up the outline of what we're going to talk about. All right. Well, thank you all for joining. We are going to talk today about various issues and concerns that you may have beyond the type of entity to form, which there was a nice webinar last week on that, which has been recorded. You know, every case is different. So this is just general thoughts and things to think about. Obviously, as to your specific case, you should talk to your attorney or a SCORE mentor or some other advisor to figure out exactly what you need. But that being said, let's jump right into it because we do have a lot to talk about. The first thing we want to talk about, licenses. Some businesses or sale of some products require licenses. For example, if you're a doctor or an accountant or a lawyer, you obviously need to get licenses. Similarly, there are people in the trades that need licenses, like plumbers and electricians. Um, Beyond that, there may be some products that you sell that you need a license for. For instance, if you're selling cannabis-related products in Massachusetts, you just can't start doing that. Or if you're selling pharmaceuticals, and other regulated products, you're going to need licenses to do that. Uh, Beyond that, depending on the nature of your business, you may need some other local licenses. For instance, if you're running a restaurant, you're going to need some health permits, people on health to sign off, or if you're doing a daycare center or the like, you may need some, state sign offs on that. So you should always consider, as you're thinking about your business, do I need any special permits uh, in order to run this business? For instance, if you're going to have an open flame because you're doing something, you may need a fire permit. Um, and then, of course, the question is, where are you doing the business, which we'll get into in leases. But the reason I bring up the where is because there may be some other requirements that you need to uh, deal with. For instance, zoning. Is your business permitted to be operated in the location that you want as of right, or do you need to get a special zoning permit? Are you bordering conservation land so that you can't build there, or you have certain restrictions on what you can do on a portion of the land and how to set up your property. So there are all sorts of licenses. I haven't hit them all, but as you're starting your business, you need to think about what licenses do I need to run the business. One thing that you may do if you're in a sales type business, you may need to get a sales tax account with the Commonwealth so that you'll have an account to pay your sales tax into. So there are just different things to consider. So before you even start on your business, you need to think about, do I have all of the permits and approvals that I need in order to run it? The next thing I want to talk about are leases, because a lot of people lease office space or retail space or manufacturing space or whatever. And the first point I have is a practical point, not a legal point. Location, location, location. You know, are you going to be in a location that's easily accessible to your clientele? Are they going to be able to, you know, locate your business easily? Is there parking available? Are there other competitive businesses in the same area? That's more in terms of a retail type location rather than an office location. But location is important. And, when we talk about permits, you're going to probably, if you're in a retail location, going to want to have a sign, or if it's a strip mall, have your name on a sign. You may need permits and license from the city or the town in order to put up the sign and what the sign can be in terms of size and, neon lights and so on and so forth. So location is very important. And, also when you think about location, there are certain rules regarding handicap access. Are you going to need to have your landlord make alterations, or are you going to need to make alterations to make your location handicap accessible? So, looking at the space, looking at the location, as I said, not a legal point, but probably more important than some of the legal points you'll get into. Now, you may hear the term triple net leases. Um, Most leases, you pay a base rent, which is you pay a certain set sum of dollars every month, uh, and that is your rent. But in a lot of leases, especially if you're located in a building that has lots of offices or lots of retail, the landlord will probably suggest to you that it be a triple net lease. And what that means is triple net to the landlord. So in addition to your monthly rent, you're going to pay a share of the landlord's insurance costs, a share of the landlord's taxes, uh, real estate taxes, a share of the landlord's maintenance charges, and potentially some other charges, but those are the three common ones: insurance, real estate taxes, and maintenance. So if you're going into a mall and the landlord's going to be responsible for, plowing the snow, well, all the tenants in the mall are going to pay their share. But the share is generally based upon the percentage of square feet that you have compared to all of the square feet in the building. But it's important that you understand if it's a triple net lease, because those costs can change. If you're paying real estate taxes, today the taxes are 1,000, next year they're 2,000, the amount you're paying goes up. The same with insurance charges and area maintenance charges. So, as you're doing your budget and projecting out what it's going to cost you to occupy the space, you have to build in something so that you are projecting not just what it is this year, but in the future. Now, sometimes tenants can limit their share of the costs by asking the landlord to pay only any increase in costs from the day the tenant takes possession forward. So in other words, if the landlord's taxes last year were 1,000 and they're 2,000 this year, you'd say to the landlord, well, you were paying 1,000 anyhow. I'll pay my share of the difference between 1,000 and 2,000. I'm not going to pay my share of 2,000. So, sometimes you can achieve that, and another way of controlling your costs. Now, if you don't have a written lease, you could be a tenant at will. A tenant at will basically means that either you or the landlord can terminate the lease on 30 days notice, 1 month rental period. So if on March 15th, you want to terminate, you give them notice by March 31st that you're terminating as of April 30th, and the lease is over. The benefit of that for a small business or a startup is, your commitment is limited. You can get out of your commitment pretty quickly. The problem with that is, you're trying to build up a business and get people to know your business at a particular location. And, you may have put some expense into renovating the location, and you don't want the landlord to be able to say, in 30 days, you're gone. So, we can work preferably with a term, and you can negotiate different terms with the landlord. Landlords may want a 3-year term or a 5-year term or a 10-year term or whatever it may be. If you're just starting out, you probably want the term to be as short as you can, and also have an agreement with the landlord that you have the right to extend the lease beyond the term as long as you're not in default. That's later down in the list under options to extend, so that, let's assume the landlord says, I want a 10-year lease. And you say to the landlord, I'll tell you what, I'll take it for 3 years. And then before the end of the 3rd year, I'll let you know if I want to extend it. And so if I do, I'll extend it for another 3 years. And so it can get up to 10 years, but you have checkpoints at which you can say, I want out, or I want to extend longer. When you extend, the rent will change. There are different formulas that people use to determine what the rent is during the extension period. Some is the cost of living index, consumer price index. Others you negotiated at the time. It says fair rental value at the time. So if the rental market's hot, your rent will go up. If it's the rental market is cool because of COVID and everybody's leaving offices, maybe your rent goes down. But having a term, I would recommend, is better than a tenancy at will. Unless if you're a pop-up store, tenancy at will is fine. You're there for 30 days, you have to leave, you leave. But, if you're really looking to set up a business at the location, you'd want a term and try to keep it as short as you can and get as many options to extend as you can. The next thing you need to think about in terms of taking occupancy is what work has to be done. The landlord could say to you, what you see is what you get, as is, where is. And then you have to budget in what is the cost of renovating this, putting in a new bathroom, putting in, dividing walls, putting in, new flooring, whatever it may be. But you can negotiate with the landlord for the landlord to pay for some of these things as construction allowances, and have him required to complete certain work before you have to start paying rent. So it's very important, I think, if you're renting space and you think work has to be done, that maybe you consult an architect of your own to come up with a plan, and then talk to the landlord about what the landlord is going to do to change it. Because, some of your modifications will inure to the landlord's benefit. When you leave, if you put in new fluorescent lighting, you're not taking the new fluorescent lighting with you. That's for the landlord's benefit. If you have to put in ramps to make it handicap accessible, that's going to be for the landlord's benefit forever and ever. Similarly, other permanent things that you put in, as opposed to decorative changes and temporary walls and the like. So you can negotiate with the landlord, what is he going to do to get the place ready for you, and what is your obligation to undertake. I had a recent SCORE client whose HVAC system in the place that they were looking at was broken. The landlord said, well, you have to pay for the new HVAC system. And they said, I don't think so. That's your responsibility. Now, mind you, when the landlord adds agreement to do some construction items, he may, instead of charging you $1 a foot, may charge you $1.50 a foot to recoup his costs over a period of time. But, from your perspective, before you move in, you may want the landlord to do work on his nickel, and you may need to do work on your nickel. So you need to understand who has what obligations and in what condition the premises is going to be delivered. Use limitations. If this really more applies to a retail business than an office type business. But if you're in a certain strip mall or mall, the landlord may say that I already have a drugstore, you can't be a drugstore, or I already have a pizza shop, you can't be a restaurant. So you may want to negotiate these for your benefit too, depending upon how much leverage you have in the situation. If you're a small startup, you probably don't have a lot of leverage to negotiate this, but it's always worth a try. But you need to know what you can and can't do, and what the landlord can and can't do with the rest of his space. You wouldn't want to go in there and open a pizza restaurant and then have the landlord open a different pizza restaurant 2 doors down in the same space. That's not good for your business, and probably not good for the landlord either. But so you need to understand what limitations. Most leases will say that you can use the premises for the following purposes, and only the following purposes. And other leases will say you can use the premises, but you can't use it for a Hallmark gift card store because we have a gift card store in the mall. So be cognizant of the use limitations, and if you can negotiate some protection so that you don't have a competitor opening up in the same mall, that would be very helpful. Options to purchase. I had a SCORE client who ran a restaurant, and the rent was really a big impediment to them. So they wanted to buy the premises from the landlord. They had in their lease that they had the right to purchase the premises after a certain period of time of occupancy for a set price that they negotiated at the time. You can have an option to purchase that says you have the right to purchase it, and the value will be determined at the time that you elect to purchase it. But if you're thinking that you may want to buy the building or the condominium or whatever it may be, you can negotiate that into your lease so that you have the first right to buy, or right of first refusal, which means if the landlord wants to sell, he has to come to you and say, I'm selling this building, do you want to buy it? I find that for many startups, this is something that is not focused on rightfully so, because you're just worried about getting into business and making money, not worrying about buying the building. But this particular score client had the insight to negotiate this in their lease, and the difference between what they were paying in rent and the mortgage payments they would make was going to be substantial. Assignment limitations. Let's assume you get into a lease and you now want to get out of the lease. You want to sell the business. You want to just close up your business, but you have 4 years left in your lease, and you want to, find somebody to take over the lease so that you can get out of that obligation. You need to be cognizant of the assignment provisions in the lease. Leases generally will say that you cannot transfer the lease without the landlord's consent. And transfer means either assign it or sublet any portion of it. So you want to look at that and see if you can get the landlord to agree to let you freely transfer the lease, which I'd say is not a likely occurrence, because obviously, landlord's concerned with the quality of the tenant, the operation and maintenance of the space, and the tenant's financial ability to pay. So he wouldn't want you to assign the lease to a certain type of business, or to people who weren't financially able to pay the lease. So it's unlikely that the landlord would agree to let you freely transfer the lease. But at the same time, you could negotiate specifics, which is the landlord will consent if the following occur, but generally, the provision is going to be you can't assign the lease without the landlord's consent. And but you need to know that if you're looking to sell the business, I mean, even if you have a successful business and you want to sell your pizza shop to me, I can't just take over the lease. I have to go to present landlord with financials, and he has to do a background check on me and say, okay, it's okay, sell the lease to Berman. So that's an important thing. And when people are trying to get out of lease, like in COVID, I was talking to a lot of SCORE clients who were looking to terminate their leases because basically they had massage businesses, no one was coming to get a massage, or they had other in-person type businesses. And each time we would look in terms of what is their right to transfer the lease, and in 99% of the occasions, they didn't have the universal right. They had to get the landlord's approval. So that's something you need to be aware of. Defaults under the lease. Very important that you look at the default section, because this is, if you default in the lease, the landlord can terminate the lease and evict you. So in the defaults, you're going to want to make sure that you have some grace periods. For example, if the rent is due the first of the month and it gets there the second, you don't want the landlord to say, I didn't get the first, you're out. So, generally we try to build in a grace period that says if the landlord doesn't receive payment within X number of days when due, 5 days often works. Obviously we try to get as much time as we can for the tenant, and the landlord tries to get as little time as possible. But you don't want you're on vacation and you send the check 2 days late. You don't want the landlord to be able to default you. And I say check because I pay by check. I'm old fashioned, but you guys probably do ACH or Venmo or whatever. But you don't want to have the landlord throw you out because you're a day late with the rent payments. Similarly, if it's not a payment default, you would want some time to cure if it's curable. For instance, let's assume that you had the obligation under your lease to keep the front of your store free of snow. And there's a snowstorm and the lease says within 12 hours you have to clear it, and it's 13 hours. Or if you have to keep your business open from 9 to 6 and you start closing at 5, you want the landlord to give you notice that you're failing to comply with the lease and give you a chance to fix it. And so what we often do is we ask landlords for, if it's not a payment default, you have to send us a notice telling us what we're doing wrong and give us 15 or 30 days to fix it. And if we don't fix it in the 30 days, or we don't start fixing it because it may take longer than 30 days, then you can evict us. So as you look at defaults, think about, you don't want anything to be immediate. You want some grace periods in order to perform on a timely basis. If you default nevertheless, and the landlord wants to terminate the lease, the remedies are important. One thing you don't want the landlord to be able to do is to say, we have a 7-year lease, we're in year 2, you now owe me for the next 5 years. Um, you know, your obligation should be to pay the rent every month as it comes due. You don't want to have to write out a check for 5 years rent right away. So, if the landlord has an acceleration clause where he can declare the rest of the rent for the rest of the term due and payable immediately, you want to try to avoid that. Similarly, you want the landlord to agree that if you default and he evicts you, that he will use reasonable efforts to mitigate the lease damages. So you don't want him to sit back and just say, okay, I'm going to collect my $2,000 a month rent for the next 3 years, every month from them. And so it's going to cost you 36,000, 2,000 times 36 is $72,000 for not having occupied the space. You want the landlord to go out and try to find another tenant. And, if the rent is $2,500 when he gets that other tenant, then you should not have to pay anything. If you can only get a tenant for $1,750, then you should make up the difference between $2,000 and $1,750. But the landlord does not necessarily have an obligation to do that. You need to put in the lease that the landlord will use reasonable efforts to mitigate his damages and therefore limit what you have to pay. Now, landlords may do that, but they may also say, well, you have to pay the broker's fees, you have to pay any renovation costs. I mean, you can negotiate what that means, mitigation, but you don't want them just to sit back and have you responsible. You want them to try to go out and find a replacement tenant. A lot of clients have asked me about subordination or non-disturbance agreements. This is basically a 3-way agreement between you and the landlord's mortgage holder. And what this says is that the mortgage holder's rights are superior to your rights as tenants. So that if the landlord defaults on the mortgage and the mortgage holder forecloses, basically your lease is terminated. Now you say, why would I sign that? And the other reason you sign it is because the mortgage holder gives you a non-disturbance agreement, which says basically that if when I foreclose my mortgage, you're not in default of the lease, and you stay not in default of the lease, you can stay there for the rest of the term of your lease. So the landlord basically, the mortgage holder says, I can terminate your lease, but I won't do it as long as you stay not in default. So that gives the mortgage holder what it needs, and it gives you what you need in terms of, the comfort of knowing that you can stay in the premises as long as you're not in default. And as I said, there are so many other things that leases contain. The last one I made a note of is force majeure. And force majeure basically says if there's an act of God that prevents you from performing, that performance is delayed until the act terminates. So act of God's, war, riot, government regulation, or whatever. The reason I put it in COVID. Clients would come to me and say, isn't COVID force majeure, so I don't have to pay rent? And the answer was not necessarily. If you look at force majeure clauses now, force majeure will say include things like pandemics, and it doesn't abrogate your obligation to pay rent. It just says you don't have to do it as long as this condition lasts. And so you want to look at your lease to see what the force majeure clause says. Oftentimes it will say, even if there's one of these events, you don't have to perform your lease, except you still have to pay me when due. That's what the landlord likes to get. So that, if you have to stay open from 9 to 5, you don't have to do that during this event, but you still have to pay me rent. That's where you want to negotiate it. They still have to pay me rent. You want all obligations put on hold during that time. All right, before we move on, Teresa, are there any questions so far?
No, I don't have any questions posted. So,
Okay,
yeah.
okay, well, then we'll keep moving on. All right, we just talked about leases. Let's talk about other contracts you may have as a business owner. First is employment contracts. Now, are you going to hire employees? And if so, will they be at will? Will they be for a specific term or as an independent contractor? At will basically means they can quit at any time and you can fire them at any time. So the employee has no expectation of a job. It's just as long as he stays in your good graces. And at the same time, you have no obligation to continue to employ somebody who is not performing the job. So I think for most employees at the outset, you probably want an at-will provision. Alternatively, a lot of startups try to hire people as independent contractors. And the reason they do this is if you hire an independent contractor, you do not have to, withhold taxes, Social Security, Family Leave Act, and give any other benefits. So if you have an employee, you give him his weekly paycheck, you need to withhold, the federal withholdings, the state withholdings, and the like, and make your employer's contribution. If it's an independent contractor, you don't have to do that. If you give your employees 1 week vacation, you don't have to give independent contractors any benefits or and the like. There's a very strict test for independent contractors versus at-will employees in Massachusetts. And I will say a lot of my SCORE startup clients say, they're going to try to hire people as independent contractors, even though they may technically not be. And, that's a risk they're willing to take because they don't want to make these other payments. But if anybody finds that these people were really employees, you have to pay all the back taxes, and there's some fines and penalties as well. The difference between the independent contractor, you hire him to do a specific job, and you have no control over him or her. You just pay him a fixed price. So, your toilet backs up, you call a plumber, the plumber comes, you pay him, $7,000, and in 5 minutes he's done fixing your toilet. He's an independent contractor. He's not in your employ. He leaves you, he goes and does this for other customers. And most independent contractors would have, other customers. They're free to work for anybody else. They're not limited to working for you. The gray area comes, when somebody is, for instance, let's assume that you have a consulting business of some sort, and you're overloaded, so you bring me in to help. Am I an independent contractor or am I an employee, a part-time employee? That area can get gray. If I'm doing consulting work for 6 clients, I'm probably an independent contractor. But if my sole client is you, you may be deemed an employee. So it's a discussion you should always have with your advisors in terms of, is this an independent contractor or an employee? And if it is, question, what are the risks to me going one way or another? And the risks in general arise when the independent contractor leaves your employee and complains about you to somebody. And it doesn't take much for a disgruntled person to complain and say, he didn't treat me as an employee. I mean, look right now, the whole thing with Uber and Lyft, where they're trying to be determined whether they're employees or independent contractors. And that's on a much larger scale, but that's, you can, if you follow it at all, you see what a big deal it is and the cost that each person is running. I also talked about employment people for a term. So you may want to employ an executive for a term. So for instance, if you're going to bring in somebody from outside the company to be the chief executive officer of the company. You may not want that person, with the bonuses you're paying him and the finder's fees and everything else. You may want him to sign a contract that he's going to serve as your president for 3 years and go from there. So with your executive officers or your key employees, you may want to lock them up for a term so that they can't just leave in 30 days. So the situation is going to vary depending upon who it is, what you're hiring them for, and whether it's a contractor or an employee. A lot of people like to include in their employment contracts a non-compete that if you leave my employ, you can't work in the same business. Those are generally frowned upon by courts and states. California, they're totally non-enforceable. Other states have provisions that make them enforceable if you've given proper disclosures and you limit them. So in other words, it's not that they can never compete, but they can't compete for 6 months in Boston. But, if you said they couldn't compete for 5 years in all of New England, that may not be reasonable, may not be enforceable. So I think non-compete clauses, you should look, depending on if you're in Massachusetts or a different state, you should get advice in terms of how to properly form one so it's enforceable. But more importantly, I think, are non-solicitation clauses, which again in California are unenforceable. But non-solicitation means when you leave my employ, you can go out and you can work in the same business as mine, but you can't solicit my customers and clients, and you can't solicit my employees for a period of time. So that, I could not leave the company, take your 5 best employees and go after your 5 best clients and go start my own competing business. So you'd have a non-solicitation for a period of time where you wouldn't be allowed to solicit employees or customers. Now, the problem with non-solicitation is proving it. I leave, I go out on my own, and Johnny, who works for you, says, I really liked working with David. I'm going to go work for David. Now, how are you going to prove whether I called Johnny and said, come work for me, whether I had a side deal with Johnny when I left, or whether Johnny just said, I'm quitting and I'm going to work for David? Similarly with clients, I've had situations where clients, I left my employ and I went and opened a new law office, and the client says, I hired David. I didn't hire your old law firm. I want to go with David. You know, how do you prove whether I went out and solicited them or whether they left on their own accord? So it's not a black and white situation, but it's always good to have that in a contract, so at least you can point at something. Non-disclosure is also another important point, which is if you have any business trade secrets or business intellectual property information, the people won't disclose that. And they can only use it when they're working for you. They can't use it in another situation. So for example, if you have a customer list and your customer list says, I've got these 22 customers, I should not be able to tell anybody who's on your customer list. If you have some novel invention that you're working on, I should not be able to tell anybody, the invention and how you're going about it. So you want your confidential business information to be your confidential business information used by your employees or contractors only for purposes of doing their job with you, and not put out to any third party or in the public domain. Important to have that type of thing if you're having an employment contract. Now, let me just diverge for a second here. We're talking about employment contracts. Many businesses don't have employment contracts, but what they do is they have a employee policy manual that will lay out these things. So, you give it to the employee before he starts work and says, here are the rules of working here. One, you can't solicit. Two, you can't disclose. And there'd be other things that you may put in there, like, you can't wear jeans to work. You have to wear a jacket and tie. Probably not relevant today. Um, you know, your vacation, you're entitled to 1 day of vacation for every 6 months you work here. After 6 months, you're entitled to get onto our health plan. So on and so forth. And, may say things that if you feel like you've been harassed, this is the procedure you follow. So whether or not you have an employment agreement, it's often advisable to have a company policies booklet that everybody reads and knows what the deal is working for this company. And, those policies can change and the like, but you should at least have it laid out so that everybody knows these are the terms of your employment and these are the benefits that you get. Now, obviously, back to the employment contract, compensation and benefits. Are you paying this person on an hourly basis? Are you paying this person a salary? Is the person entitled to health insurance? How much of the health insurance do you pay for? How much do they pay for? Is there disability insurance, vacation time, sick days, personal leave, and so on and so forth? This all should be set forth in the contract that we're talking about. I see a few chat. Are there questions here, Teresa?
Yeah, can we, yeah, I'd love to get those in. Is a virtual assistant that works for multiple companies and sends you an invoice, is that still considered independent contractor?
Um, you know, there's no black and white rule, but I would say that that would tend to be an independent contractor because the assistant is not just working for you. It's working for many people providing similar, let's assume it's the assistant was a bookkeeper. She's your bookkeeper. She's a bookkeeper for XYZ company, ABC company. I'd say she's an independent contractor if she's working for lots of company. One of the things that people get tripped up about is the independent contractor just works for them, and that's where they get into trouble. Whereas if uh, you were a consulting firm or an individual providing services to 5 or 6 companies, you're probably an independent contractor, I would think.
Okay. Is an employee hired for a term subject to withholding?
Yes. Yes. If you hire me as your president for 3 years, my weekly paycheck, you'll take out Social Security, federal taxes, other employer contributions, and the like. So yes.
Is a paid intern considered an independent contractor?
Um, I would say a paid intern is probably a part-time employee. But, the intern's just working for you presumably, and, is coming in and doing daily tasks based on what you say. It's not really one project necessarily. So I think a paid intern would probably tend to be a part-time employee.
Should you work with a lawyer to develop your company policies? Can you use templates to develop these? What is the legal way to go about developing your company
You're asking a
policies?
lawyer whether you should go to a lawyer? The answer is I would work with a lawyer just because there's so many technical areas here, and there are some people who are employment law experts. That being said, there are some good templates you could use, but what I would do before I put that into effect is I would still run it by a lawyer. Say, listen, I've come up with this form of agreement. Can you take a look at it and let me know if I'm legally okay with this or if you have any suggestions to add it? I would also suggest that SCORE has many counselors who have experience with employers and employees who could, review what you prepare or talk to you about what you should have in your document to prepare. But ultimately, I think our recommendation would be you should run whatever you come up with, whether it be with your SCORE mentor or on your own, through an employer because the law is constantly changing. And, for instance, if you're located in Massachusetts, your employees in New Hampshire, which law applies? So there's just a lot of technicalities. So I think the answer in a roundabout way is yes, end up with a lawyer, but B, you can probably do some of the work on your own and have the lawyer look into it after you do it.
Okay, thank you. Yeah, we're at 15 minutes left, so I'll let you keep going.
Okay. Okay. All right, so let's talk about other contracts. Other than employment contracts, you want to be very specific about your services that you're rendering. For instance, you don't want to say in your contract, I'm going to provide you with consulting services. I mean, that's too broad. It's going to lead to dispute. I always tell people be as specific as you can. I'm going to consult with you regarding setting up a computer system where you can schedule your workforce, because you don't want to end up in a situation where somebody says, I hired you to do this, and you say, no, you hired me to do this. You want to be very specific so that if you're setting up a computer system to schedule the workforce and the client comes back to you and says, I want you to do something so I can schedule meetings with clients. That's an additional service for which you'll get additional pay, not part of the original. So being as specific as you can is very important. Uh, Payment terms, are you going to be paid in full at the end of the job? Are you going to get a deposit? For instance, if you're building a house, you usually get a deposit up front, and then every month you submit an invoice to the homeowner and or the building owner, and you get paid for work to date. And you do that until the building's completed uh, and the like. So how are you going to be paid? Um, and you have to think about that as well, because, if you're a builder, just to use that example, you're going out and buying materials to do the construction. So you're coming out of pocket for that, or are you going to get a deposit that's going to cover those costs? And basically, you'll get paid for the work as you do it, but you're going to have your materials covered up front. It's all a question, and part of cash flow and part of, credit worthiness of who you're dealing with. Some people say payment in full upfront. I just took some pictures to be framed. They said 50% upfront, 50% when they deliver. You got to think about what the payment terms are going to be. And, how long is the engagement? And so on and so forth. And, you also want to think about that if somebody doesn't pay, if you're supposed to be the recipient of the payment, should you be getting interest on it? And if you have to sue to enforce the contract, they should pay your legal fees and other expenses, because you don't want to end up in a worse position because you had to sue somebody. You should be in the position you would have been if they had performed. So payment terms are important. Exclusivity, if exclusivity can come in different ways. One way is, for example, let's assume that you're a manufacturer and I'm going to sell you nails. Am I going to be the only person you're going to buy nails from? Or are you going to have the right to buy nails from other people? Do I want you to be the only person I'm buying nails from? Obviously, as a business owner, you probably want to have more than one source in case one source can't deliver. But on the other hand, if somebody's consulting with you on a specific project, maybe you don't want him working with other people on the same project. So, an example of that would be, when I was in business, there were occasions when I'd work with a lender, and the lender would be working with people who wanted to buy the company. And then there'd be another group that wanted to buy the company. So, did the two groups want the same lender to be working on it, or did they want, the lender to be exclusive to them and not help anybody else buy? So exclusivity is something that may come up. Warranties, you don't want to promise anything. It's basically it. Your services are as is, whereas no warranties of any kind. That, you're just giving your best professional advice, but you're not guaranteeing anything. Um, and for example, I had a SCORE client who provided college counseling advice, and one of her clients called her after college admissions and said, "My son didn't get into Harvard. What good were you?" She says, "I never promised you I'd get him into Harvard. I promised you I'd help him get his resume together, his essay together, et cetera, et cetera. I'm not guaranteeing you anything. If you're a psychologist and somebody comes in for a consult, you're not guaranteeing them that they're going to walk out cured of all their problems. You're doing your best, you're giving your best professional advice, but you're not warranting or guaranteeing anything. And that's, something that you want to be clear on. Is not that you're saying, I'm not going to do a good job. What you're saying is, I can't guarantee you what's going to happen as a result of this. As opposed to if, I go in and I buy a TV from Best Buy and the TV doesn't work, basically I get to return it because it didn't work. But if I didn't get your son into Harvard, you don't get to get your money back. And similarly, that ties in with limitation of liability, which is if there's a breach of contract, a party can sue you for all damages that it can prove. And in some cases, I'm sure you've read that courts award punitive damages as a punishment for the action. So the contracts we like to see would provide that there's no punitive or indirect or special damages, and also that your liability is limited to what you were paid for the service. So that if you charged $1,500 for a consulting session and some court found you liable for having given bad advice, you give them back the $1,500. Personally, I think that's somewhat, I'll use the word outrageous, but that's too strong a word. In that, if I spend $100 on your service and to put in a new electrical line in my house, and my house burns down because you put it in wrong, I shouldn't just get my $100 back. But that's just my personal feeling. But representing clients who are providing services, we try to say the most you can get back is whatever you've paid me. I'll bring you whole if I did something wrong. Indemnification, if you're doing a job for somebody, you don't want to be sued by anybody else on account of that job. So let's assume that you were consulting with a company on how to terminate people, the process to terminate employees who you wanted to terminate. And you went through and set up a form with them, and they went through it, and an employee sues because they said the termination violated something, their contract or whatever. You as the consultant want to not be in the line of fire of the employee. You want the employee sues you and the company, you want the company to be responsible for that. So basically, if you mess up, you're responsible. If you're negligent, grossly negligent, or intentionally do something, you go in and you punch somebody in the face, you're going to be responsible. But if you perform your duties to the best of your ability in accordance with reasonable standards, you want the company, whoever is hiring you, to be responsible if somebody's going to sue because of your advice. The last thing is dispute resolution, and by far these aren't the last things. These are just highlighted things. If you're in a dispute, are you going to go to mediation? Mediation is you sit down with a third party who tries to talk you both into a resolution, not binding at all. So I say, that Teresa owes me $10,000. Teresa says I only owe him $2,000. So the mediator would hear my side of the story, her side of the story, come back to me and say, why don't you take 8,000, go back to Teresa and say, why don't you pay him 5,000 and try to bring us together? But if we don't agree, we don't agree. Then there's arbitration, which is binding. It's usually faster than a court proceeding. And, the parties each pay half the cost of the arbitrator generally. And so this would be binding. It would be like a mini trial before someone who's a lawyer or other expert in the field. And you present your case with witnesses and the like, and the arbitrator would make a decision, and that would be it. That would be a final binding decision enforceable by either of you. And then, of course, there's going to court, which takes time and has its own challenges. So you need to decide, how do you want to resolve your disputes? Teresa, I see some more. You want to ask more questions?
Both of them are kind of about naming companies and entities. So I think we're gonna have to save those to the end. Unless you want me to.
No, no, I leave, you're the guardian of the ship there. So let's click over briefly, and I will say to everybody, I've never been able to finish this in 60 minutes, so I'll go on, but I understand if some of you have to leave. Intellectual property. People want to protect their intellectual property. What is intellectual property? Trademarks, trade secrets, patents, copyrights. Trademarks can be protected at a state level or at the federal level. You likely want to protect them on the federal level because that protects you across the country. Doesn't protect you overseas. You'd have to get foreign patents in the country, trademarks in the country in which you're going. So like Disney, when it opened Disney France, had to get Disney trademarked in France. But it does protect you nationally. If you get a state trademark, that just protects you in the state. With business being international as it is, you want to go to the U.S. Patent and Trademark Office. Not a hard process. We do have counselors who have done this their career and can be very helpful in that. But you can do it yourself in some extent. If you want to trademark the name McDonald's, you can go to the U.S. Patent and Trademark Office site, uspto.gov, and they have a search where you can search. So you type in McDonald's, and it'll bring up all the people who've protected the name McDonald's. And if it's a restaurant, you're probably going to have trouble. But if it's McDonald's child's socks, you may be able to protect that because it's not the same business. But trademarks are one thing to protect. Patents and copyrights, similarly, there's the Patent Office, U.S. Patent and Trademark Office, and U.S. Copyright Office. Copyrights are like if you're an author of a piece of work, you could go to the Copyright Office for that. Patent is if you make the newest and best widget. You do need expert help with those two areas because they're very technical and very complicated. So those areas you would want to get an attorney, but there are ways to protect them through government protection. Trade secrets aren't necessarily trademarks, patents, and copyrights, but it could be you're a restaurant and you have a recipe for lasagna that's out of this world that nobody else in the world has. And so that's a trade secret. So, you want trade secrets protected. And one thing that I recommend with trade secrets is we get back to the confidentiality provision we talked about in contracts, is you should have a policy that employees acknowledge or a contract that says they will not disclose your trade secrets to anybody else. That is essentially if you really have something that's secret and unique to your business. I'll quickly move on to insurance. Most businesses, especially if you're going to be seeing clients in person, you'll want personal injury and property damage insurance so that if somebody slips and falls in your place of business, the insurance company is going to pay the claim. Or if somebody drives his car through your Apple window down on the South Shore, the insurance will cover the property damage. Now, personal injury and property damage, they can be purchased at different levels. You can buy personal injury, say I want insurance up to $300,000, I want insurance up to $1 million, depending upon the nature of your business and the risks that you think you see. You want a larger coverage and the cost will be more. You also will have deductibles likely. So if you say, I'll pay the first 500 on my own, that's different than you say you pay the first 5,000 on my own. There's a different risk for the insurance company. So you should work with an insurance agent on that. But one thing I would say for those of you who were on the webinar last week about limited liability companies and corporations and protection from personal liability, I still recommend, even if you have an entity that supposedly protects you, that you get insurance as well. And the reason for that is the insurance will cover your defense costs. Insurance will also give you 1 page of what they'll cover you for and 24 pages of exclusions. So, you need the limited liability company or corporation to protect you, but the insurance is on top of that, because let's assume you have a successful company and you've got, $1 million in the bank from all your sales, and somebody slips and falls in your place of business and makes a claim for $500,000. You don't want to take $500,000 out of your business bank account. You want the insurer to pay for that so that you keep your viability of your business. So I think personal injury and property damage insurance goes hand in hand with, regardless of the entity that you form. Also, there's product liability insurance, which is different than personal injury and property damage. Product liability will come in, especially if you're selling food, drugs, any sort of product where a consumer is ingesting it, or even things like toys. You sell a toy and you always read about kids choking on this or that, and they blame that the product was improperly designed. So if you're in a business that's providing a product, you want to talk to your insurer about product liability insurance, so that if something's defective with the product, that put something in and somebody had an allergic reaction to your cookies, that you're going to have insurance to cover that. Briefly, key man insurance, if you're in a company and you're not the sole owner, and something happens to you and you want to be bought out if you die, sometimes the company will buy key man insurance. So it would say that, you'd have a contract that if something happened to me, the company would pay me or my estate $1 million. And so rather than the company having to pay the $1 million, they take out $1 million insurance policy on me, a term policy. And if something happens to me, the insurance basically covers the buyout. That's important, not only in terms of buying out the person who passed away, but it also could provide you, depending on what you have to pay on the buyout, pay you funds to go search to replace that person too. Not usually something startups would get, but as you grow your business, you may want to think about this. And lastly, business interruption insurance. COVID, the big question was, if I had business interruption insurance, did I get covered? And the insurance companies took the position, no. But business interruption insurance, for instance, if there was a fire in your place of business and you couldn't conduct business for 2 months, the business interruption insurance would pay towards your losses because you couldn't conduct business because of the fire or the flood or whatever it may be. So that's something to consider depending upon the nature of your business. A lot of businesses we do at home, on Zoom. So our business doesn't get interrupted for something like that. But if you at a retail store and there was a fire or a flood, or if you're in Tampa and the roof blew off your business, business interruption insurance would help protect for some of the losses you incur by virtue of your not being able to conduct business. I know it's quick, and I know there was a lot there, and that's why I started by saying, feel free to consult a SCORE mentor or your professional advisors to get into more detail on these. But this is just sort of a taste of a lot of the things we were talking about. Teresa,
Can
are there any
we,
more questions?
yeah, if we can just hit on a couple quickly, if they're not quick answers, then maybe they can set up appointments. Single member LLC, drafting services, made their LLC in Wyoming. They do all of their work drawings while in their home in Massachusetts, but all the clients are outside of the US. Do they need to register the LLC in Massachusetts, as well as potentially a foreign LLC?
It's a good question. Technically, if your business location is in Massachusetts, you should be registering as a foreign LLC in Massachusetts. Because that's where you're doing business. You're presumably paying taxes in Massachusetts based upon your business income here. And Wyoming was just set up because it was less expensive to set it up and maintain it in Wyoming. So I think the prudent advice would be to file as a foreign LLC in Massachusetts. I know it will cost you $500 a year, which is painful, but I think I probably would. Now, in terms of clients being in foreign jurisdictions overseas or whatever, whether you register there, I think you'd have to consult the local laws. You know, I can't tell you whether if you're in UK or in Pakistan, whether you would need to register your business there. But I do think if your headquarters is in Mass, all your work's being done in Mass, you should probably qualify as a foreign LLC in Mass. Now, does that mean people do that? Not necessarily, but I think that the proper legal advice is you would do that.
Okay. If you're not happy with arbitration, can you still go to court?
Most arbitration is final and binding and can be enforced by the court, but there is arbitration where the parties can say that it's not going to be binding, and you can go to court. But I'm not sure why you would do that other than the hopes that you could resolve it through arbitration. But most arbitration, the parties agree, is final and binding, but that's not necessarily absolutely have to be the case.
Okay. Somebody's asking about recommendations for insurances or brokers. Do we have
We
those on
do,
our-
we do, on our, we do have a list of referrals.
Okay.
Where are they located? Are they in Boston or New Massachusetts?
Yeah, I don't know. So I would say go ahead and email us and oh, she's in Houston. Nope, we don't have that list.
No, we don't
So
have that list.
you might reach out to your local chapter and see if they have a list of referrals. Well, a lot of
Okay,
chapters do. Um, Somebody's asking about getting a name, how you know what name is allowed for your business.
okay. So let's just assume you're forming it in Massachusetts and in most states as well. You can go to this Massachusetts Secretary of State website, just Google in corporate name check Massachusetts Secretary of State. And then it will come up and you'll put in the name you want and you'll hit search. And if there's another company using that name, it will come up. And if there's not another company using, and that would be a corporation or a limited liability company. If there's not a corporation using that name or limited liability company, then it will say no records, and you'll be able to use that name. And there's a process that you can, through the Secretary of State website, reserve that name so nobody else can use it for 6 months. So if you're just starting your business and you say, I want to be Berman and Lang, then we could save that name for 6 months while we form our business and get it up and going, and nobody else could use the name. In terms of national names, you go to the Patent and Trademark Office and check, but there's no reason, if there's a Berman and Lang in California LLC, we could form Berman and Lang Massachusetts LLC. That's not going to be the issue. The question is whether Berman and Lang is a trademark name across the US and you couldn't use it. So you go to the US Patent and Trademark Office and check to see if that name was being used nationally and protected nationally, not that it was being used, whether it's protected nationally. So Secretary of State is your first check.
Okay. And I'm actually putting in my email, because we really have run out of time, outreach@scoreboston.org. David has open times and Bill has open times. They're both our legal mentors in the Boston area. Certainly you can also reach out to your own chapter for a legal mentor. I know I'm getting like follow-up comments onto questions. And it really is easier if you set up an appointment and they can actually talk to you specific about your business, and it makes it more beneficial to you. So we're going to start it there. And thank you, everyone. And thanks, David. And have a
Okay.
great rest of your day, everybody.
Thanks, Teresa.
All right.
Bye-bye.
Bye.